If you were arrested for domestic violence in California, this video is for you because I'm going to be explaining the 3 top factors that lead to one defendant getting a better outcome over another defendant, all other things being equal. So you guys have the same background, it's the exact same police report, but person 1 gets his charges dismissed, maybe person 2 goes to jail. My name is Veronica, I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you how to represent yourself at your restraining order hearing and win. So if that is something you're dealing with, in addition to having been arrested, you can get your free first class in the course via the link down below. Okay, so let's jump right in. The top 3 reasons why some defendants get better outcomes than others. And I'm talking about where the police report is the same, the alleged victim is the same, the background is the same. In fact, let's make it the same person, right? In universe 1, maybe your charges get dismissed or you have a clean record. Universe 2, maybe you end up with a felony on your record and going to jail or prison. And number 3 actually might be the most surprising of all these, so make sure that you stay tuned for that. All right, number 1, proactiveness. Okay, so as a defendant in a criminal case, or even as somebody who is arrested and you don't know if charges are going to be filed against you or not, you can do. You may feel like nothing is in your control right now, but there is actually a lot that you can potentially do to help your case. I'm not saying do anything DIY. I'm not saying contact the detective or the DA yourself. That is crazy. That's a bad idea. Some of the things that you can do are hire an attorney right away. Obviously, I am an attorney, but I know that people are watching this who couldn't possibly hire me because I only take cases in California. You want to get an attorney right away so that they can tell you what to do, so that they can tell you, hey, go to domestic violence classes, go to therapy, give me character letters. All right, tell me what happened and give me the evidence that you have, and let me contact the DA before court and try to increase the likelihood that they drop the charges. Now, you might think, well, why can't I just wait until a week before court? I just paid, I just bonded out. Maybe, this happened in the midst of a breakup and you were moving out. The reason is that the DA is going to, at some point, look at the police report and anything else that is in the file and decide whether or not to file charges against you. The longer you wait, the closer it gets to your court date, the more likely that the DA is going to make a decision and maybe file the case without your attorney having a chance to contact them first, without them hearing any of the good things about you. But let's say that you have been to court and unfortunately charges already were filed against you. That doesn't mean that there's nothing that you can do. You can look at the police report. Your attorney should be giving you a redacted copy of the police report that has certain information blacked out. They should be giving you that. And generally, we want you to continue to go to classes or go to therapy or go to whatever we're sending you to, because we want to be using this time to build your mitigation, to show the DA that you are not a criminal, and especially if you have no criminal history, that this entire situation really freaked you out and that you never want to be in this situation again, okay? The DAs know that a lot of people are told to go to classes or told to go to whatever, AA, therapy, and people do not want to do it. A lot of people in that same courtroom that you will be in, they refuse to do classes. They don't think that it's a big deal. They don't really care. They don't follow the judge's instructions. And you know what they look like then? They look like criminals, and they're going to end up probably back in that courtroom another time. If you can show the DA that, hey, no, this is not what you want for your life. You're not okay with being arrested. You're not okay with being in this criminal system. You are willing to follow instructions because someone instructed you to go to therapy or go to these classes. You're willing to comply with all of that. That differentiates you from everybody else so that you have a chance at potentially getting the case dismissed in exchange for those classes, some of which you already did. Number 2, your attorney's actions. Is your attorney persistent? Is your attorney counseling you to be proactive? Does your attorney know your case? Or is your attorney just going to try to get you to take the very first deal and hang you out to dry? Unfortunately, that does happen. With public defenders, they're just very busy. I think that largely they do care about their clients. They just have so many of them. And when they're negotiating with the DA, when they're talking to the DA about a case, they probably have at least 20 cases that they're talking to the DA about. And so it can be hard to make you in particular stand out. And then sadly, some private attorneys that really don't care. I don't know why they became attorneys in the first place, but they really don't care and will just try to get you to take the very first deal that you were offered, often at the very first court date without really doing anything. They're just trying to close the case as quickly as they can, not be persistent, not set more court dates, not just accept no when the DA says it the first time, but keep going and keep going and keep fighting for you. And I know not just my own experience, but I've seen so many of these negotiations. I've seen where the defense attorney doesn't know anything about the case, when they don't know if the client has criminal history or not, when they can't answer basic questions, when they just asked the DA, hey, I need an offer on this case, without explaining to the DA, my client is a great person. This is what they're doing. They've gone to so many classes. I have all this proof, and actually really advocating for their client. Number 3, unfortunately, is luck. Which county is it? What are the politics of that county? Which DA was your case assigned to? All of those are factors that are, for the most part, outside of your control. When Gascon was first elected, and if you don't know who that is in Los Angeles, that is our district attorney, who's very controversial and polarizing for being basically soft on crime. Okay, when he was first elected, I was in the middle of an attempted murder trial. There were like 34 or 36 counts against my client. The best offer that the DA was willing to give him was, I think, 15 to life. They had physical evidence. They had witnesses. We had just finished our jury selection. I was rehearsing my opening statement, and I get a call from the DA offering my client, he was offering very reluctantly, time served. Now, that particular client, he had hired me not too long before, but his case had actually been going on for several years before this. And had he accepted a deal, or had Gascon not been elected, he never would have been given that offer, right? Had we had the trial, 2 weeks earlier, he would not have gotten that offer. But he just got really freaking lucky. I hope you found this video helpful. If you do have a criminal case in California, feel free to give me a call. You can find my number down below. You can also book a call there. And if you did find it helpful, please don't forget to like, subscribe, ring the bell, and follow me on Instagram, TikTok, and Facebook.